Hey there, welcome back to another episode of Sidekick TV, another lockdown special. So today I'm joined by Kirsten Maclean from Sidekick Legal. We've put this video together because we've had quite a few frequently asked questions about the wage subsidy, how we can treat the wage subsidy and our employees through this period of time. So firstly, welcome Kirsten, thanks for joining us.
Thanks for having me, good to be here.
Cool. Kirsten, we'll kick straight into the questions that we've got. So of these 5 questions, the first one was that, so talking from a business owner's perspective here, so if I get the subsidy, can I just automatically drop everyone's pay to 80% or less, or cut back their days worked?
Yeah, look, that's one that we're seeing a lot come up again. It certainly was one that was front and centre last year, and there was a lot of confusion around it in the early stages of the wage subsidy. One thing that's been reinforced and made really clear this time is that employment law remains on foot. And by that, it means you can't just unilaterally change employers' terms and conditions of employment. And that includes days, hours, pay, those sorts of things. So there are 2 aspects to that. So in terms of the dropping to 80%, again, it's much the same principles and guidance as last time, in that if you have the wage subsidy, you have to use best endeavours to top that up, ideally if you can to 100%, if not to 80%. And the key about that is remembering to have clear evidence. Talk to your advisors. The Sidekick accounting team I know are talking to clients all day about these sorts of things and keeping the evidence about cancelled jobs, deferred jobs, cancelled orders and things like that, which would then provide the necessary evidence that they had used best endeavours to meet their financial obligations. So that still remains the policy and the approach. In terms of, and I'm getting a lot of questions about that, well, can I cut back their hours, or I think one of the other things we're going to touch on, but it's probably appropriate to talk about now, can I force them to use sick leave and annual leave? And that comes back to variations which have to be agreed. So yes, you can do that if you've consulted with your team and they've agreed to it. And it might be that not all of them agree, but some of them agree. They might have time in lieu banked, they can use that, but again, you can't force them to. You have to have the discussion and the agreement with them. And I think the other thing to say is when we're talking about evidence of financial constraints and restraints, also keep evidence of that. So keep an email from your employees saying, yeah, I'm really happy to use my annual leave, or I'm really happy to use some time in lieu, just so that you've got that there. We saw last year a lot of employees change their mind after the fact and raise grievances about having their pay docked and things like that. So, and also one of the things I'm saying to a lot of clients is, it sounds strange, but imagine that we weren't in a pandemic and imagine that we weren't in lockdown. Would you do those things? And if the answer is no, because you can't just change the terms of an employee's employment, the same things apply regardless of the fact that we're in lockdown. So it's just keeping that in mind.
Perfect. Thank you for that. And look, yeah, you did answer the second question very well there about asking clients to use, employees to use sick leave or annual leave. And look, this is something that we've seen a lot, and we saw it last lockdown with a number of our clients. So it really does come up, and also seeing it where clients and their employees had totally different interpretations of what was going on. With I thought I was just having leave off work, just being paid to not work. Whereas the employer was thinking, no, I was wanting it to be sick or annual leave. Okay, so taking on to the third question there. So do I include casual employees in wage subsidy applications?
Yeah, look, the short answer to that is yes. If they're employees, they qualify, casual, temporary, fixed term. I was just working with a client over the weekend who have approximately 2,000 casuals, so they've got a massive job ahead of them in applying for the wage subsidy. One of the things with the casuals, and I'm seeing a lot of, and we see it in normal days anyway, is the differences between casual and permanent part-time. So I had a query yesterday about a casual employee, but actually it transpires that she's been a permanent part-time employee for about 6 months or more because she works 3 days a week for a set number of hours. So it's just about identifying what category they fit into. The one thing that there's been some issues or confusion about is working out the average or ordinary weekly earnings for a casual. Now, in a truly casual sense, that's often difficult because their work is as and when needed, ad hoc. So the law is that you look at the last 4 weeks to work that out, and that's under the Holidays Act. There is, however, some rather confusing guidance on some of the government websites that with casuals, you should be looking over the 12-month history. Now, I suspect that's arisen because last year a lot of casuals missed out, because if they are truly casual, then there's a real chance they wouldn't have worked in the last 4 weeks for that employer. So when you're faced with those concerns and those questions, the fallback is always going to be applying the principles of good faith. You know, what is reasonable in the circumstances, but the starting point is the law dictates that you look back over the last 4 weeks to work out what the average or ordinary weekly earnings are.
Great. And because this often comes up in for seasonal workers, doesn't it? Is that the tricky thing? So what kind of industries are we looking at there?
A lot of things like I'm dealing with a couple of nurseries, sort of vineyards, things like that. And there's some guidance for that. So when it's seasonal work, you sort of look at you would be better to go longer or to compare it with the previous season to sort of get an idea. So if you're, you know, and also, mind you, it's essential services, but I mean, if the agri industry wasn't with carving, you know, the hours that they work are significantly more than at other times of the year. So if you're finding it really hard, just reach out and get some advice specifically about that employee or that group of employees. But if it's more reasonable and a lot fairer to look over a longer period of time or to compare it to the comparable time last year, the comparable season, then probably err on the side of caution and do that. And the reason I say that is because if you're ever challenged, the courts and the Employment Relations Authority will look at, well, was it a reasonable and fair decision that the employer made? So if you're comparing apples with apples over different years, then it would be hard to argue that that was unfair.
Great, yeah. So it comes back to that record keeping again then, doesn't it? And making sure that, yeah. So the next question here. So what do I do if I have new employees due to commence work during this lockdown period? Because they presumably won't be starting.
Yeah, a couple of things about that. And actually, I had a call just the other day about that very thing. Our client's got 4 new employees due to start on Monday. So what the wage subsidy deals with employees who are legally employed by the employer. So from the starting date under the contract, unless it's agreed to defer that or push that back, which I imagine a lot of new employees probably won't want to because they'll be left in a limbo where they're not employed and how do they get support. So let's say, for instance, we're in level 4 for another week and you've got employees due to start on Monday. From Monday, they will be legally employed by you. And therefore, my advice is that they would qualify as your employee for the wage subsidy. So that's an option open to you next week for new employees. Some might be open to deferring their start dates. And also bear in mind that if we go to level 3, there'll be a lot of businesses that if they can't work from home, they can work under the level 3 protocols. So it's just about, I guess, touching base with those new employees too, just to make sure there's no health or immune concerns or the extra measures don't need to be taken if they are going to be going into a level 3 protocol workplace.
Perfect. And then this is one of my favorite ones from last year. I couldn't believe that there were people with this attitude, but what happens if we have work for employees to do from home, but they're just refusing to do it?
Funnily enough, I'm seeing a lot of that this week too. I was talking to a very disgruntled employer yesterday he's adapted the workforce so that he's got work for them to do so that they keep paying, and he's paying them, and they're just refusing to do it. They're wanting a paid holiday. And look, I appreciate that there are additional demands on people, particularly people at home with children, single parenting families where they're trying to manage everything. That can be really stressful. But the expectation, of course, is that if there is work available and it's to be done from home, and as long as the employer is flexible about when that's done, then the expectation is that they work and they get paid for that work. Now, of course, if they're being offered work and the ability to work from home and they're refusing, as I say, take the pandemic and the lockdown head off. If you had an employee who was refusing to come into work and do work, you wouldn't be paying them because they weren't attending to work. So they can't expect to refuse to do any work and get paid. So it's those same principles, but it's also about us as employers being mindful that, you know, people might be feeling extra pressure this year because they know what happened last year and how long it lasted, and so they might work different hours or different ways or take time out during the middle of the day to go for walks and things. But certainly if you've got work for them and they're refusing to work, then they can't expect to be paid.
Yeah. No, thank you for that. It's yeah, because it is, like you say, it's a really challenging situation for a lot of employers because they're walking on eggshells and they're scared and don't know what rights might still exist for an employer.
Yeah, and I think the other thing is this time around, there's been a lot more information. There's been a lot more media about the cases that have been to the Employment Relations Authority, and in a number of those, wrong decisions were made under pressure and haste by employers, and so employees have been successful. So employees have a lot more information and knowledge as well, but also bear in mind that, as I say, the employment law principles remain, and that's a dual obligation of good faith. You know, that obligation of good faith doesn't just sit with the employer, it also sits with employees. So, you know, employees need to be acting with good faith and reasonably and you know, within the circumstances that we find ourselves.
Perfect. Thank you so much, Kirsten. We'll wrap up there. That was great. So we'll post this video along with those questions, and we'll be around. It'll be in the Sidekick Business Lounge and on YouTube. But if you have any questions, please do pop them in the comments. Thank you very much, guys.
Great. Thanks, Rick.